Recently, the Black Lives Matter movement has garnered the attention of the American public due to the spate of unarmed African Americans being killed by police. But a key component of this tragedy is being overlooked. Many of the highest profile victims of police brutality have something in common: disability. Kadeen Powell, fatally shot by the St. Louis Police Department, had a history of mental illness. Freddie Gray, who died in the custody of Baltimore police, was reported to have an intellectual disability. Tanisha Anderson, in an agitated state due to having bipolar disorder, was slammed into the ground by police shortly before she stopped breathing. Eric Garner died in a chokehold at the hands of Staten Island police. He was asthmatic. And Sandra Bland died in custody after accommodations for her epilepsy were not sufficiently met. According to David M. Perry, a leading journalist on this issue, up to 50% of all police brutality cases involve people with disabilities. While specific details vary by case, the common threads that link these stories together are often disconcerting. Law enforcement officials expect and demand compliance, but when they don't recognize a person's disability in the course of an interaction, the consequences can be tragic. Misconceptions or assumptions can lead to overreactions that culminate in unnecessary arrest, such as people with cerebral palsy routinely being suspected of drunk driving, or deaf folks being perceived as resisting arrest because they don't hear the orders. Sadly, while incidences of this sort aren't necessarily new, for many of us, learning about them is. The internet, social media, and cell phone footage have helped catapult stories that were once easily restricted to local police blotters to unprecedented national prominence. Where does this problem stem from, and what can we do about it? 26 years ago this week, President George H.W. Bush signed the Americans with Disabilities Act, the ADA, into law, calling it powerful in its simplicity, and explained it will ensure that people with disabilities are given the basic guarantees for which they have worked so long and so hard: independence, freedom of choice, control of their lives, the opportunity to blend fully and equally into the rich mosaic of the American mainstream. But it hasn't been so when people with disabilities encounter law enforcement, especially people of color. And that intersection of race and disability starts in schools. A disproportionate number of students of color are diagnosed with learning, cognitive, and emotional disabilities. Compared with their white peers, Black students are twice as likely to be identified as emotionally disturbed and 2.7 times as likely to be identified as cognitively impaired. Researchers attribute this disproportionality to cultural or linguistic differences that may be misinterpreted as symptoms of a learning disability. For young Black youth, this academic and social unrest invariably leads to school suspension and then the juvenile justice system. And with the incarceration rate having jumped 450% in the last 30 years, and with so many inmates having a disability diagnosis, it's no wonder that there is an association between criminality and disability. Discrimination against disabled individuals during arrest is a particularly structural and embedded form of discrimination which often goes unrecognized. An officer who is taught to use force when confronted with what she perceives as a threat may apply that knowledge when responding to a mentally or physically disabled person, not realizing that by treating this person the same way as she treats others, she may in fact be failing to reasonably accommodate his disability and thereby discriminate against him. But surely this discrimination is recognized by the courts, right? Only sometimes. According to the University of Pennsylvania Law Review, disabled plaintiffs can and should bring claims for police misconduct under the ADA, but many cases of police discrimination get thrown out because it's often argued as to whether an officer knew the plaintiff was disabled. However, one way disabled plaintiffs are winning their cases is to claim that police departments and local governments are failing to appropriately train officers to interact with disabled members of the community. A violation of such would fall under Title II of the ADA as failing to make reasonable modifications to its policies, practices, and procedure to ensure that his needs as an individual with a disability would be met. With more lawsuits aimed at the structural shortcomings in our police departments, the better chance that trainings will be implemented and higher levels of conduct practiced, bringing law enforcement attitudes in line with the social model of disability that all people with disabilities deserve. When we leave disability out of the conversation or only consider it as an individual medical problem, we miss the ways in which disability intersects with other factors that often lead to police violence. Conversely, when we include disability at the intersection of parallel social issues, we come to understand the issues better and new solutions emerge.